unconstitutional and therefore invalid. But my Lord, I propose to deal with the points as set out in our answering affidavit, and then thereafter to deal with the issues raised in my learned friend's argument.
Okay, that's fine.
My Lord, the first issue is jurisdiction. My Lord, it is clear, and I think it's that portion is confirmed by my learned colleague, that they rely on the unlawfulness of the dismissal. And therefore they say, my Lord, that dismissal is therefore invalid. Those dismissals are invalid. That appears clearly from paragraph 15.2 and 16.10 of their supplementary affidavit. On the other hand, my Lord, they have elected to come to this court, and of course they are relying on the LRA, even if partially so, my Lord. But they cite, for instance, section 157(2), particularly in relation to this jurisdictional issue, my Lord. And we submit, of course, that the only constitutional issue that can be raised in this case would be an issue relating to section 23 of the Constitution, which is the right to a fair labor practice, which is now codified under the Labor Relations Act. My Lord, the issue of the rights of freedom of expression under section 16 of the Constitution does not arise simply because this is an employer-employee relationship and there is a breach of contract. It's not relevant for purposes of this argument what the issues were between the parties, between the employer and employees. But my Lord, it is an issue between employer and employee. Hence they have come to this court.
Can I ask you, I don't know if you had a chance to look at the reference that was made to the Lotteries Board case? Where that seemed to come out as an issue.
Yes, my Lord. As far as I'm aware, my Lord, the Lotteries Board issue, this issue, that's the distinction, this issue of a contract, in other words, a prohibition contained in the contract, does not arise, my Lord. It may have been a constitutional issue in what the employer was trying to restrain the employees from doing. But this case is an additional and very important element. There is an agreement between the parties. And my Lord, these are not unsophisticated people. They are journalists. But my Lord, I'll come to that aspect. At this present stage, dealing with the jurisdictional issue, I wish to refer to the case of and we have placed reliance in our heads of argument on the case of Steenkamp. My Lord, and we've quoted extensively from that case in paragraph 2 of our heads of argument.
Okay.
My Lord, the essence of that case in our respectful submission is that once a dismissal is pronounced, it takes effect. And it may not be avoided by pleading that actually the dismissal was unconstitutional and so on, and therefore seek to set it aside or declare it as void. But then we must deal with the dismissal, and the only way to deal with it would then for this court to say that that dismissal was unfair, either procedurally or substantively. And my Lord, I must also emphasize that the issue also referred to in the Lotteries Board case is of automatically unfair dismissal, which, if one looks at the applicant's case, to a large extent goes to that actually this dismissal was motivated or based on victimization, which then would fall under the category of automatically unfair dismissal, which would therefore clothe this court with jurisdiction. But my Lord, that's not their case. They have deliberately elected to bring it on different bases, which is the unlawfulness of the dismissal. My Lord, I've quoted, I don't think I need to reach each and every quotation in the case, from the case of Steenkamp. But my Lord, I wish to refer to particularly paragraph 44, which is on page 3 of 144 from Steenkamp's case. My Lord, the second part thereof, which reads, accordingly, the dispute falls to be resolved under the dispute resolution provisions of the LRA. The applicants cannot avoid this result by alleging that the dismissal is invalid and of no force and effect. What this passage means, in part, is also that if a litigant's case is based on a breach of an LRA obligation, the dispute resolution mechanism used must be that of the LRA, and the remedy must also be a remedy provided for in the LRA. Accordingly, on this ground, the appeal must be dismissed. My Lord, this again emphasizes the very submissions that we have made, that in order for an employee who comes to this court must allege that there was an unfair dismissal. My Lord, there is a dismissal now, and I'm speaking after the dismissal was made. I'll deal with the other prayers. I'm dealing with prayer 1A in particular of the amended notice of motion. There has been a dismissal. The issue of whether that dismissal can be or should be set aside should be dealt with in terms of the Labour Relations Act. And particularly, my Lord, when one seeks reinstatement, because that remedy is carefully carved in the LRA. It's a remedy which is carefully circumscribed in the LRA, and it says that it can only be granted if there has been a finding of either of unfairness of the dismissal. And my Lord, that's I've already said that that's not the applicant's case.
Can I just ask you, Mr. Badlander referred to two cases, one by Judge Basson and I forget the other one, both of which he argues hold that you can seek to have a termination of a contract,
yes,
which was terminated contrary to the terms of that contract, to have that termination declared invalid.
Yes, my Lord.
What do you say about those cases?
Yes, my Lord. In fact, I was going to deal with those cases. But, my Lord, I can say that those cases, of course, deal with the breach of contract by the employee. First of all, my learned friend doesn't refer you to other parts of the policy that he relied on. He referred, Your Lordship, to paragraph 1.8, for instance, of the policy. The essence of which, and he says that...
Just hang on 1 second. 1.8.
1.8, my Lord.
Mm-hmm.
He says that paragraph is irrelevant for the purposes of this case. My Lord, yes, my Lord, what is important about this paragraph, it also defines or describes what summary dismissal mean in terms of that policy. In other words, it would be a dismissal without a formal disciplinary hearing. It says in that paragraph 1.8. And, my Lord, the policy continues, and particularly there's a second part of the policy which is on page 289 of the papers. Page 289, paragraph 1.2, which refers to misconduct and offences warranting this summary dismissal. Among them, my Lord, we have 1.2.3, deliberately causing negative reporting of SABC affairs in the media. My Lord, and perhaps while I'm still on that point, my Lord, the contracts of the employees, if I may refer them to as the employees, excluding the first applicant, refer to both the policy as well as the regulations as forming part of their contract. That's paragraph 6.37 of their contract of employment. It incorporates the regulations and this policy or the disciplinary code as part of their contract. My Lord, may I please, before I continue with my argument regarding the jurisdictional point, say that the regulation that has been referred to, Regulation 2D, says that the journalists may not comment in the media regarding their conditions of service. And my last friend says now that's unconstitutional. But it doesn't end there. It further says that without prior permission from the authorities, yes, my Lord, it says there must be permission obtained or consent of the group chief executive. So, my Lord, this argument of this clause being unconstitutional cannot stand. There is no allegation, for instance, that they requested permission and it was refused or unreasonably refused. So, my Lord, it cannot be argued that the policy is unconstitutional. Going back to, my Lord, the jurisdictional issue. My Lord, I also want to bring your Lordship's attention to paragraph 5 of our heads, which is, we are quoting the case of De Beer, from which we've also relied extensively. My Lord, which that paragraph reads, it is significant that in terms of Section 193(1) of the Act, it is only if and when the Labour Court or the arbitrator appointed in terms of the Act finds that a dismissal is unfair, that reinstatement may be ordered. And then it goes further to explain what reinstatement means, which we all know. My Lord, we therefore submit that, my Lord, the reinstatement that is sought in Prayer 1A in the circumstances, the applicants may not argue that these employees are entitled to such reinstatement on the basis of this course of action. My Lord, we go on in our heads of argument to refer to the case of Intervalve on paragraph 7 of our heads, which is also a recent case of the Constitutional Court. Still to the same effect that, my Lord, that where a matter has concerns dismissal, then it must be referred to conciliation. For conciliation, otherwise the Labour Court has no jurisdiction. That's on paragraph 115 of that case, in paragraph 7 of our. My Lord, may I also mention, because there has been a reliance on Section 157 of the LRA that says that they may raise a constitutional issue before this court. But, my Lord, account must also be taken of subsection 5 of that section. Good enough section 158.2 states that the Labour Court has concurrent jurisdiction with the High Court in respect of fundamental rights which arise from employment and from labour relations. But subsection 5 states, except as provided for in section 158 sub 2, the Labour Court does not have jurisdiction to adjudicate an unresolved dispute if this Act or any employment law requires the dispute to be resolved through arbitration. My Lord, of course, this Act requires that section 158.2 is the one that deals with the Labour Court sitting as an arbitration proceedings. My Lord, then we simply say that even if they are raising a constitutional issue, that does not exempt them from complying with the mechanism provided for in terms of the Labour Relations Act.
What do you say about the argument, as I understood it, that look, we're coming and saying our case is not a case of unfair dismissal in the normal way the LRA provides for that kind of relief. We are here saying that for the reasons we've been dismissed and in the manner we've been dismissed, we actually are entitled to rely on contractual principles. Does the Labour Court not have jurisdiction to deal with something in that context?
My Lord, our submission in that regard is that this is a simple dismissal, like many other dismissals, based on the breach of the terms and conditions of their employment, my Lord, which I've just referred your Lordship to, in particular, Regulation 2D, my Lord. Of course, the applicants state in the replying affidavit now, they've gone, I think it's paragraph 18 to 21 of the replying affidavit, goes extensively to deny, number one, that, look, I didn't do that. I did not go out and speak about this policy to external media. But, my Lord, number one, they elected not to respond to the Schedule 8 notice. Schedule 8 notice stated clearly, and it's not correct that it was vague, stated clearly the instances where they commented on the policy to the outside media. And then, my Lord, instead of making representations to the Schedule 8 notices, they elected to come to this court. In other words, they in effect, my Lord, they simply saying, no, look, we're not going to deal with you. I don't know whether that meant we don't recognize you as an employer. We are going to make representations to the court. Worst part, my Lord, is that they don't even make their, knowing very well that this issue, my letter friend in his opening statement says, we came to this court, and I think it was in relation to the jurisdictional issue. Say, we came to this court about the Schedule 8 notices. In other words, the employees were dismissed on the basis of the Schedule 8 notice. But, my Lord, they don't deal with that. They don't deal with that even in their founding papers. They choose to deal with that in the replying affidavit, clearly, depriving the respondent of that opportunity, especially in an urgent application. And my Lord, perhaps if they had put up this version, and the Lordship will see, as I've said, is paragraph 18 to 21 of the replying affidavit. It's extensive and substantive representation regarding those allegations contained in the Schedule 8 notices. If they had put up those, which we believe it was within their knowledge, they had that information. If they had put up those representations, maybe we would not be here today. The case may have been different, but the attitude was different. The attitude was that, no, we're not answerable to you. We are going to make our representations in court. And my lord, that point, must say, I'll make submissions at the end, goes also to cost, even, regardless of the result of this case I submit, my lord. My lord, to close the issue of the jurisdictional point, I just want to we have stated there that if the issue of jurisdiction is crucial, as paragraph 9 of our heads, and is directly linked to the validity and status of the order made by the court. In other words, that's the beer case, the LAC, my lord, which says, in other words, and it's emphasized in the case referred to in the next paragraph, that actually a court made by the court which lacks jurisdiction is invalid, and maybe it's not. It states so, my lord. It's not me. It's that case. If I can read that paragraph on page 7 of our heads, a court must have jurisdiction for its judgment and or order to be valid. If the court does not have jurisdiction, the judgment or order is a nullity. No pronouncement to that effect is required. It is simply treated as such. That's the Transvaal Provincial Division.
I doubt there'd be any disagreement about that.
Yes, my lord. I'm simply saying, in case, my lord, if you are correct, in other words, that the court has no jurisdiction. And my lord, I proceed to deal with the issue of the incompetence of the orders, in particular. Prayer 3 and 5. First of all, my lord, let me emphasize also that in terms of the format in which the notice of motion has been, the amended notice of motion has been done, actually, it is very clear that prayer 1A is a permanent interdict. Because, my lord, there is 1A, there's 1A, and then 2-3. But prayer 4, which would perhaps have made it an interim interdict, refers to prayer 2 and 3. In other words, it says those are only prayers which would be operative on an interim basis, pending the decision of those fora referred to. The decision of those fora referred to. In other words, prayer 1A is not affected thereby. So it is clearly a permanent one. And in any event, my lord, and we've referred to authority, and in particular the De Beer case, that actually it is extremely difficult to fashion the remedy of reinstatement as an interim remedy. Because it's permanent. If you reinstate, you reinstate it. It cannot be interim. We have referred, it's in our heads of argument, my lord, that portion of the LAC decision in De Beer's case. My lord, I've already, I was dealing with the incompetence of prayers 3 and 5. My lord, simply the prayer 3, we didn't deal with prayer 2 because we don't, quite frankly, my lord, we're not too sure what that means. My learned friend has perhaps correctly referred to the founding papers and says, no, it read together with the founding affidavit, perhaps it was referring to the suspension. But now, our view is that we have actually a new course of action. We have now a dismissal, and number one, the suspensions have fallen away. They have no relevance. And the disciplinary proceedings as well, in terms of prayer 3, have also fallen away, my Lord. In other words, if this court finds that the employees must be reinstated, then, my Lord, they cannot. Otherwise, either the employer must reinstitute or institute new disciplinary proceedings. The disciplinary proceedings and the suspension has been overtaken by events. There's now a dismissal. In effect or de facto, there has been a termination of the relationship between the parties.
I just want to understand the point. Does the reinstatement, let's just for argument's sake say you're dealing with the reinstatement back to a date of dismissal, doesn't that normally imply continuity of the relationship? And though there may have been, before the order of reinstatement, a complete break, the reinstatement, so to speak, heals that complete break and continuity resumes. And as I understand the concern expressed in terms of the relief is the concern of the applicants is if we were reinstated, if we don't also stop the disciplinary proceedings which were pending when we left, they might be reinstituted or continue. Maybe I'm missing something in your...
Yes, I'm also not sure if I have said your Lordship correctly, but if it means that now they cannot discipline their employees after they've been reinstated, then I would submit that this court ought not to do that, because then you would be the management would have now not to be able to exercise their rights against their employees. But my Lord, I'm referring to that insofar as it refers to the disciplinary proceedings that had already been instituted before the dismissal. Our submission is that the dismissal was, of course, based on different and new acts of misconduct. Those acts of misconduct were committed after the disciplinary proceedings had been instituted, and as well as after they had been suspended. Those were suspended.
So in your submission, what would happen, let's just for argument's sake, let me follow that. What would happen to those that were initiated in June, for example? Those, because as I understand the SABC's argument, you're saying, look, people were not dismissed for what we were charged with, for what they were charged with originally. They were charged with what was in the Schedule 8 notices.
Yes.
Or rather, they were dismissed for that. Yeah. But then what happens to that previous disciplinary procedures or proceedings which, as I understand SABC to be saying, those were not sort of completed or followed through?
Yes, my Lord, my submission is that have fallen away, and those disciplinary proceedings. And my Lord, there is no way that they can say now you are reinstated, we are continuing with the disciplinary proceedings. They will have to institute new disciplinary proceedings, and my understanding is that the applicants are not interdicting the institution of future disciplinary proceedings, but they are actually interdicting the continuation of those disciplinary proceedings that had been instituted. And my Lord, my submission is simply that with the dismissal, and I've already referred to that, the dismissal is a fact, which of course can be reversed by the court, but it is a fact. There has been a dismissal, and everything else falls away. In other words, it's a clean slate, if I can put it colloquially. My Lord, that's the That's going to be our argument as far as these 2 points, which is jurisdiction and the issue of the incompetence of the prayers. My Lord, as far as merits, which I've already, through your Lordship's question, already covered most of it. The simple issue is that there is a contract of employment which prohibits certain behavior and conduct by the employees. They have breached those terms of contract and therefore also committed acts of misconduct which were contained in the Schedule 8 notices. My Lord, insofar, and at the risk of repeating myself, insofar as they have dealt with in the replying affidavit, we submit that should either be ignored or struck out by this court because they had the opportunity to deal with that, at least in the founding affidavit. They didn't deal with they didn't make representation to the employer for whatever reasons. Secondly, they don't deal with it in the founding affidavit, knowing very well that's the reason for their dismissal. In fact, my learned friend says in opening that these employees, or these were attempts by SABC to silence or to stem out criticism of the SABC's conduct internally and externally. Now the question would be, externally, and we are interested in the external part. By whom? If it's by these employees, and to some extent, I was under the impression that he actually concedes that part. These employees went out because he says it was their constitutional right. Went out to criticize their terms of contract in the media, which is prohibited in terms of their contract of employment. And as I've already said, it cannot be argued that term is unconstitutional. It makes room for obtaining permission. My Lord, insofar as the question, and I'm trying to deal now with the issues raised during argument, the public perception your Lordship raised regarding the retraction of the statement and policy, and of course, my Lord, that has happened. Those facts are correct. What has happened in the regarding the decision of ICASA in the High Court, the Ellen Suzman Foundation, my Lord, but this deals not with their refusal to comply with that policy, which has been, one can call it rendered unlawful, but with them going out and criticizing their conditions of employment in the media externally, which is prohibited by their contract of employment. And my Lord, so far as I think the question also, or that submission also answers the question whether the issue of the radio journalist, that the statement did not affect them. Of course, my Lord, that's a side issue, and my learned friend did state that. But it's about what is contained in the Schedule 8 notices, and which is conduct prohibited by their contract. It's not about the validity or rather the unlawfulness or their refusal to comply with the terms of the policy. No. It's about their criticism. My Lord, I'm simply running through my notes just to see if I'm not missing something. I've already covered the point that the lotteries case is distinguishable on the basis that there was no contractual prohibition in that case. And my learned friend has also mentioned that the order made in the Helen Suzman Foundation case, it's an interim order. It's subject to the review in Part B of the notice of motion in those proceedings. My Lord, also one aspect that I need to deal with is the Section 77(3) of the BCEA. My Lord, I think I've dealt with that, but just for purpose of emphasis is that there is no breach of contract here, because the contract, of course, incorporates the disciplinary code. But the disciplinary code does not simply or does not end at saying you cannot discipline except through formal disciplinary proceedings. It makes room for disciplining without following formal disciplinary proceedings. In other words, a process such as Schedule 8 process.
There was a point raised earlier that the code and Schedule 8 are applicable, and that it's not a you can choose one or the other situation. What do you say about that?
I beg your pardon.
So there was a point made in argument that, as I understand it, the phrasing was that the employer must follow the code and Schedule 8, but it didn't say or Schedule 8, it said both. And you seem to be suggesting there's maybe a choice. So I'm just trying to look.
I'm not sure, my Lord, if that was the argument, but nonetheless, my Lord, Schedule 8 is another procedure, and I didn't understand my learned friend to be saying a Schedule 8 procedure is unlawful or does not exist. That's not the argument.
No,
there is that procedure. It was followed. What he says is the circumstances under which it was applied would make it rather an unconstitutional procedure or unfair procedure. I'm not sure what he says, unlawful. But my Lord, I don't understand the argument to be that Schedule 8 procedure is either an unreasonable procedure or is unlawful or does not exist. My Lord, the other aspect which was raised is that of course I've dealt with that. I think just one aspect, my Lord.
Sorry, can I, before you carry on?
Yes.
The point I was looking for, have you got a copy of the heads of argument? It's easier to find there, of the applicant's heads of argument.
Yes, I have, my Lord.
Okay, if you look at paragraph 18, they cite the relevant contracts of employment recording the following. Then the emphasized portion says the SABC shall be permitted to take the necessary disciplinary actions allowed and detailed in the relevant legislation and the SABC disciplinary procedures and codes of conduct. In other words, they're saying that clause means that an employer can't elect to say, well, on this occasion we're going to follow Schedule 8, we're not going to follow the disciplinary code itself.
My Lord, our submission in that regard is that, of course, the labor legislation or the relevant labor legislation includes Schedule 8, number one. And the disciplinary code does not exclude a procedure such as is provided in Schedule 8. It makes provision for that. And I've referred Your Lordship to the summary dismissal, which is on page 289, paragraph 1.2.3, regarding or relating to deliberately causing negative reporting of SABC affairs in the media. Well, that covers that situation, and there is actually a compliance. The process complies with that part of the contract. My Lord, there's also one aspect which relating to that by my learned friend who says it doesn't have to, if the contract is unconstitutional or that term of the contract is unlawful and unconstitutional, that does not have to be raised. It is simply unenforceable. My Lord, then there's a myriad of decisions that you must know what your case is before you come to court. Nowhere is it raised in their papers that they are going to ask that certain provisions of the contract be declared unconstitutional and therefore invalid. That's the simple answer to that, my Lord. And my Lord, with regard to the judgment of the case of McBride relating to the power of the court to intervene in incomplete disciplinary inquiries, my Lord, the simple answer to that is that applies where there's no dismissal, before the dismissal, not where there's already a dismissal. So clearly distinguishable. And similarly, my Lord, the submission that there's now a clear right has been shown because SABC has capitulated. That cannot be, my Lord. This is a contractual issue. I've already addressed that aspect. It's simply a contractual issue. It's not about the constitutionality and particularly the right of freedom of expression, especially vis-a-vis not the general society, but their employer, the SABC. My Lord, I believe that I've covered all our submissions.
Just on that last point, because it's clearly one of the important issues in the case. What do you? I just want to be sure I understand the SABC argument, and that is that because they subject to obtaining permission from, I can't remember whether it's the CEO or the COO, they might express public views. That means that they are not absolutely prohibited by the terms of their contract from expressing views critical of the employer outside the employer itself or outside the workplace, shall we say.
Yes, my Lord. I think it's qualified. It's not absolute prohibition. It's subject to approval, which I believe is common cause that they did not obtain such approval. They did not seek it in the first place. My Lord, the other point which I'm reminded by my learned, the constructive contempt, my Lord, which relates basically to prayer 5. My Lord, what I've already stated, I think I've addressed that issue. Number one is that the Schedule 8 notice came before the urgent application. It's not a situation where somebody brings an urgent application and then you issue a Schedule 8 and then you dismiss him. That's not the case here. There's a process that is in place. And in fact, the urgent application was an attempt to circumvent that process.
But just, I mean, if you know that parties are saying, look, hang on, we want the court to decide whether, and you're entitled to disagree and say we're quite entitled to proceed, but where you know that very issue about whether you can continue with disciplinary action is going to be the subject matter of a court hearing, what does it say to the court when you say, well, actually we don't care that it's pending before your court, we're going to go ahead anyway in the meantime, and you can deal with the consequences of that later?
Yes, my lord, that would only apply if the court agrees with my learned friend that the term disciplinary proceedings would cover also the Schedule 8 notices. Then perhaps that could be the case, my lord, but we submit that that's not the case. The term disciplinary proceedings has been referred to extensively in the affidavits. And that very paragraph about the agency in the founding affidavit, I think it's paragraph 8-9, refers to the notices, allegations contained in the notices. And they have referred to in the affidavit to the disciplinary proceedings, in other words, the formal disciplinary proceedings that have been taking place, and that that's what was required. They're supposed to have been afforded an opportunity to be heard in the context of a formal disciplinary hearing. So they know exactly when they say disciplinary proceedings, what is being referred to, my lord. There is a distinction in this case, and my lord, if
so, you're saying. Sorry, just to understand, you're saying that the SABC could not have been acting in the face of a pending application if it embarked on fresh proceedings for other reasons.
Yes, my lord. That original notice of motion referred to disciplinary proceedings, and my lord, the other aspect is that they did not seek to set aside, particularly the Schedule 8 notices. If that was the case, specifically saying these Schedule 8 notices are unconstitutional, on whatever grounds they raise, they are therefore unlawful or unconstitutional, that would be a different case. But that's not what they sought originally. They referred to disciplinary proceedings. My lord, of course, as far as issues of contempt of court, your lordship knows that the requirements are quite substantive if one has to find that a person or an official has acted in contempt. In fact, my lord, in that case, in terms of the Faki case, the criminal standard applies. It must be proved that it was intentional, and already what you are stating in the affidavit shows that at least there's a doubt that they would have acted intentionally in proceeding to dismiss them, because they don't know you're referring to disciplinary proceedings, you're not touching on this process, you're not making representations, so the process must take its course and be taken to its logical conclusion. And what may I say that my learned friend says
Well, it seems we've lost transmission there, but those were live visuals from the Labour Court out there in Braamfontein in Johannesburg, where the SABC's lawyers this time were arguing that the cases against the journalists are related to breach of contract in terms of a summary dismissal, which is a dismissal without a disciplinary hearing. Now, one of those clauses within the contract was that if they deliberated or commented on internal matters to the media, that constitutes a summary dismissal. They said the applicants are therefore not entitled to reappointments due to their conduct. And of course, they further stated that the applicants were going to take a quick ad break. We will be going back to court as soon as we establish that link.
Africa is growing. As a result, it's also advancing the way it does things.
Any developments in technology can really do a lot to boost growth.
On Network, we'll show you how technology is improving the lives of Africans.
The life of an LED globe is 15 times longer than what they have currently.
We also have new gadgets, games, and the continent's innovative technology ideas. That's Network with me, Siphumelele Zondi, every Sunday at 19:30 Central African Time.
Welcome back. It seems we have reestablished that link to the Braamfontein Labour Court. We'll go back there.
Authorities. If your Lordship has regard just to the following passages of Steenkamp, it is absolutely crystal clear that what Steenkamp was doing was deciding what the LRA position was. So, at paragraph 103, the judgment says, "My point of departure is that if a litigant's cause of action is contractual in nature, the remedy will have to be found in contract law. If a litigant's cause of action is based on the law of delict, the remedy will be in the law of delict. The applicant's cause of action is a breach of the procedural requirements laid down in section 189A8 of the LRA, and therefore has to be dealt with the remedy." So, and that point is made again and again. It's made at page 100, paragraph 103. It's made at paragraph 118. It's made at paragraph 119. It's made at paragraph 129. And it's made in the very paragraph on which our learned friends rely, paragraph 144. Steenkamp was saying, the LRA, when you rely on the LRA for a contention that the dismissal is unlawful, then you've got a problem because you've got to go to the CCMA. That has never been our case. Similarly, the new case relied on Intervale. Our learned friend says Intervale shows that the Labour Court can't deal with it, but the full passage of Intervale at paragraph 115 says that the LRA lays down the conditions before a dispute concerning the dismissal of employees for striking may be referred to the Labour Court for adjudication. That's not this case at all. So the jurisdiction point, with great respect, doesn't get out of the starting blocks, and there's been no answer on jurisdictional bases to either Ngubeni or Dayakala. The argument is that our contractual argument is wrong, and I'll deal with that now. So on that point, our learned friend appears to accept Ngubeni and Dayakala, and that must put an end to the jurisdictional point. But what he now says is he says that our contractual argument is ill-founded on the merits because, he says, the contract itself permits summary dismissal. And he relies in this regard on the second part of that document, which is called the Code of Conduct, and which appears at page 288 to 289. So, just to orientate your Lordship, the document starts at page 283, and it starts with Part 1, Disciplinary Code and Procedure, and those are all the provisions we've referred your Lordship to. It's called Disciplinary Code and Procedure. And then in the second part, Part 2, which begins at 288, it starts Code of Conduct. And one says the following are examples. Well, one qualifies everything, and says the following are examples of misconduct or offences and do not include all possible forms. 1.1 deals with less serious misconduct, and 1.2 deals with misconduct and offences warranting summary dismissal. That's the heading. Now, there are two difficulties for our learned friend. The first is that this clause was never relied on. It wasn't relied on in the answering papers as being a lawful basis. It wasn't relied on until our learned friend stood up. It is clearly a last gasp attempt to avoid the contractual problem. But more importantly, that reading of this document makes no sense, because on that reading, 1.2 allows summary dismissal for 8 different kinds of misconduct, including everything from fighting to unlawful possession of SABC property to intimidation to all sorts of things. And it renders then clauses 1.8 and 4.5 a dead letter. It is simply not a coherent way of reading the document. And your Lordship will know that when it comes to contracts, we read things in context following the decision in Natal in Ndumeni. And it seems to us that although it's poorly worded, what 1.2 is intended to say is that those are offences which will warrant dismissal as a sanction. So the reference to summary dismissal there is not about procedure at all, because it doesn't...
It's just the standard kind of disciplinary code where an employer vainly tries to capture everything an employee might possibly do wrong.
Precise. Your Lordship has the point. It's not about procedure. It's about so that's no answer. And once that is so, then the contractual argument must fail. And we would just commend to Your Lordship, in answer to our learned friend says our clients should have gone to the CCMA. The answer is to be found in Ngubeni. In Ngubeni at paragraph 19, the learned judge says you can't go to the CCMA to enforce your contractual rights. That's why you have to be able to come directly to this court. That's Ngubeni at paragraph 19, page 9 of the bundle. So the contractual argument must succeed in our submission. In any event, the constitutional argument must succeed. And our learned friend raises 2 points there, and they're both new points. The first is to say that the only constitutional issue that can be raised here is Section 23, and Section 16 doesn't arise because this is an employer-employee issue. That's plainly wrong. Section 16 will not always apply in the context of employee discipline. So, for example, if my clients were being disciplined for taking home with them SABC property, it wouldn't raise a Section 16 issue. Or if they were being, or intimidation, it wouldn't raise. But this one plainly does. And that is made clear by the Lotteries Board case. Then our learned friend says, but the Lotteries Board is different because there was no contractual provision about talking to the media. I haven't had a chance to reread Lotteries Board to check that. But the difficulty for our learned friend is that founders because that contractual provision is unconstitutional. And his only answer is that it is not an absolute bar, it's that it allows permission to be sought from the CEO. That has 2 fatal flaws in it, my lord. The first fatal flaw is as a matter of law, which is that a clause which says, a clause or a statute or a provision which says I may only speak with someone's permission remains a limitation or in violation of freedom of expression. It is called a prior restraint in our law. And our constitutional law is very well developed on the effect of that prior restraint. And there is a convenient summary of some of the cases, ironically, in the very CCC decision which found the SABC in violation of its license, the very one before Your Lordship. Could I just ask Your Lordship to make a note? At pages 38 to 40 of the bundle, 38 to 40 of the papers, paragraphs 18 to 20, the CCC summarizes some of our law on prior restraints, most notably the print media case, where the Constitutional Court has held that prior restraints, where you can't speak without permission, are inherently a limitation of freedom of expression. But there's a bigger problem, my lord, and the bigger problem is demonstrated by this case. Our learned friend argues, quite seriously, and no doubt on the instructions of his client, that what my clients had to do was they had to go to Jimmy Matthews, who was the CEO, and ask his permission in order to criticize the protest policy. That's the argument. That is the same Jimmy Matthews, it's the door or the window, Jimmy Matthews. My clients had to go to him and say, Mr. Matthews, would you mind if I criticized the SABC for this policy, which you have told me I'm not even allowed to get an independent analyst to speak about on the air? My lord, I again accept it must be a submission made on instructions, but it is cynical in the extreme. The last point on the constitutional issue is the suggestion that there's a failure to plead the issue that is plainly incorrect. No authority has been cited to Your Lordship for saying that we cannot raise what is plainly a legal matter and which arises from the answer of the SABC. And again, I say, we are not seeking an order that the contractual provision is unconstitutional. All we say is that all my clients say is that the SABC can't enforce it against them, and that goes to the cases we cited. There's been no answer at all, my lord. Penultimately, there's been no answer at all on the suspension and disciplinary issues. My learned friend does not seek to defend those. All he really says is that we can't get that relief because it's incompetent. But it's plainly not incompetent for precisely the reason that Your Lordship gives. If an order of reinstatement is given in terms of Prayer 1A, my clients will still be facing suspension and disciplinary proceedings. That has to be dealt with by this court, because otherwise we're going to be back in front of another judge a week from Your Lordship giving his judgment. It is an issue that has been pleaded, it has been canvassed, and we persist in it, and there's no answer, and it's plainly not incompetent. Lastly, my lord, on the question of costs. Our learned friend made what we say is a fatal concession. Your Lordship put to him that wasn't it inappropriate of the SABC to proceed to dismiss in the face of this application. His answer was that was only true if disciplinary proceedings referred to in the application included Schedule 8. In other words, he doesn't seem to take issue with the principle that if the reference to disciplinary proceedings includes the Schedule 8 notices, then there was inappropriate conduct by the SABC. But we say then his client's case is in desperate trouble because disciplinary proceedings must include the Schedule 8 notices, and that is for two reasons. The first is a matter of three reasons, in fact. The first is a matter of linguistics. The notice of motion and the founding affidavit refer to disciplinary proceedings, not disciplinary hearings. If we're going to start splitting these hairs, it is plainly that disciplinary proceedings includes all forms of disciplinary proceedings, whether initiated by means of a disciplinary inquiry or Schedule 8. The second reason is a reason I've already given, that the very basis for urgency was the Schedule 8 notices. So it's plain that that was part of the proceedings. And the third reason is that it would be utterly illogical for my clients to come to court to try and interdict the disciplinary hearings against them while leaving in place and allowing to proceed the Schedule 8 notices that could lead to their dismissal. On what possible basis could my clients ever have sought to do that? And there is no way that the SABC can understand that as being the basis of the case. His last point was that my client should be mulcted in costs because the explanation as to what they've done appears in the replying affidavit. My Lord, the first time that we got a proper explanation for the dismissal with specificity, there's no specificity, but the first time we got any form of specificity as to what my clients were alleged to have done in order to do the dismissals, in order to bring about the dismissals, was in the answering affidavit. In that answering affidavit, my Lord, there are the vaguest allegations imaginable, saying the applicants engaged in a protest march. The applicants spoke to the media, of which there is documentary proof, which is never put up. The applicants gave interviews to the media, who are never specified. My Lord, we were duty-bound to point out to this court, as we did in reply, that those wild and broad allegations had no basis. And so my clients were perfectly entitled to put that up in reply. The truth of the matter, though, as your Lordship knows, is that we have been prepared to argue this on the basis of the SABC's version. And so we have therefore not asked your Lordship to place considerable reliance on those facts. The case that we've put before your Lordship is, even on the SABC's own version, the dismissal was unlawful and unconstitutional, and the suspension and disciplinary was unlawful and unconstitutional. So, far from it being a case of my clients being mulcted in costs, this is a case where it's the SABC to pay the costs. And we would emphasize to your Lordship that my learned friend has advanced no submissions as to why an order in terms of prayers 5A and B would be inappropriate. We therefore ask for those orders, that the officials should be named and that they should be called upon to show cause why they should not personally be liable for the costs. We say to your Lordship, in this dispute already, we know that the SABC and the public have borne the costs of the Helen Suzman Foundation in what must have been a massive application on an attorney-client scale. Your Lordship will see that from the draft order. There is no reason that the SABC and the public should bear those costs again without at least an investigation as to whether the individuals concerned should be held accountable. Well, all those are our submissions.
My Lord, I'm not re-arguing. I know I'm not entitled.
It's been a long day.
Yes, I'm just pointing out, my Lord, so far as he says the argument about the contract.
Yeah.
And particularly regulation 2D is a new argument. My Lord, it's raised in paragraph 4.4 of our answering affidavit. They admit it in their reply.
Just give me that paragraph.
4.4, my Lord, of the answering affidavit. And in paragraph 14 of their reply, page 336, they say yes, it's not only regulation 2E but also 2D. They admit that it was the Schedule 8 notices were on that basis.
Okay, I'll have a look at that. All right, gentlemen, thank you. I will endeavour to give judgment on Monday morning, but I think the best thing is you must just check with my associate at about 9 o'clock whether it will be ready by 10. Otherwise, I'll give judgment on Tuesday, in which case I'll probably hand it down in Cape Town, or I'll ask our colleague to hand it down here. All right, so provisionally Monday, but subject to confirmation. I don't know what other matters are going to come up this weekend. It seems like there already are other urgents. Okay. All right, court's adjourned. All right.